This. అది కాదా పేరు అంటే డిఫాల్ట్ గా ఒకటి ఓపెన్ అయింది పోస్టర్ పోస్టర్ అంటే సెట్ చేసిన దానికి కనెక్ట్ కాకపోతే వచ్చేసింది డిఫాల్ట్ గా ఒకటి క్రియేట్ చేసుకుంటాను చెక్ చేస్తున్నా నిన్న చెక్ చేసి అంటే మీరు ఇక్కడ జూమ్ లో కనెక్ట్ చేసేటప్పుడు డైరెక్ట్ గా కనెక్ట్ చేశాను ఏ ప్లే లిస్ట్ ఏది సెలెక్ట్ చేసుకోవాలి అది ఆల్రెడీ ఈ కాప్ చేసి స్ట్రీమ్ అది స్ట్రీమ్ కాప్ చేసి ఆల్రెడీ ఇచ్చిండు సెట్టింగ్స్ ఆల్రెడీ ನೀವು ಹೇಳಿಕೊಂಡೆ ಅದು ಸೆಕ್ರೆಟ್ ಒಂದು ಕಾಫಿ ಸೇಮ್ 20 ಪೇಸ್ಟ್ ಟೈಮ್ ಯೂಟ್ಯೂಬ್ ನೀವು ಹೇಳಿ பண்ணிங்க ಅದು ಹಾಗೆ ನೀವು ಕಾಪಿ ಅದೇ ಸರ್ ಆಫ್ பண்ணி இப்போ பேஸ்ட் பண்ணுங்க లైవ్ వస్తుందా నాకు వస్తే డిఫాల్ట్ గా వస్తుంది ఇది దీనికి ఇది లింక్ అక్కడ చూడచ్చు ఇంకొకటి అది ఆటోమేటిక్ గా దీనిలో పెట్టుకోవచ్చు it's not download next. Go there. Download from the first one. Next one. Again start choosing stream current bit rate is lower than the bit rate. అది అన్ని డిపార్ట్మెంట్స్ కి IPR coming up with mobile will stop and will start again. Stop just
Yes, outside meeting started. Last week. Streaming
check பண்ணி இதுல எதனா ஷேர் பண்ணி எதனா ஷேர் பண்ணலாம் ஷேர் ஸ்கிரீன் ஷேர்
ஏதோ சும்மா ஷேர் பண்ணு சார்
streaming lo okay right okay so YouTube link will share already it is said once I will share WhatsApp group sir students ke share panni
second அந்த link share பண்ணு வால ஒரு faculty
YouTube link YouTube YouTube link okay sir நீங்க ஷேர் பண்ணுங்க இது faculty group ஷேர் பண்ணுங்க students so I will share to all other faculty group
இது சார்
நீங்க ஷேர் பண்ணுங்க ஸ்டூடண்ட்ஸ் குரூப் எல்லாத்துக்கும் அவங்க கிளாஸ் இது சார் இதுவும் போடுங்க இது 100 மேல ஆயிட்டேன்னா they can't able to get in sir second year third year நீங்க என்ன குரூப்ல எல்லாம் கூட அந்த கிளாஸ் அட்டெண்ட் பண்ணி ஜாயின் போட்டு ஸ்டார்ட் இந்த கோவில் ப்ரொஃபைல் ரீடிங் அது போன இதுல யூடியூப்ல ஜூம்ல சரி ஜூம்ல அது Hello, am I audible?
Yes, sir.
Okay.
Hello, sir.
Madam.
Audible, sir.
Okay. Madam, just a few minutes, sir. We'll start. Sir, Bhaskar, sir.
Hello, sir. Yes, sir.
Sir, shall we start?
Yeah, we can start, sir.
Okay. So in this Zoom meeting, 44 students are there. Remaining, they are joining in the YouTube live.
Hello, sir. Yes,
Ah.
sir. Yeah, we can start, sir.
Madam, Sabriman, madam.
Sir.
Madam, please check once your screen, is it shareable?
Yes. One minute.
Please check once your screen, is it shareable?
Okay, no, madam.
Yes, sir. 1 minute, sir. I'll join with my laptop. also.
Okay.
ನಮ್ಮ RCB
Okay. Madam, shall we start? Okay. Madam, shall we start?
1 minute, sir.
Dear participants, please mute your audio. All of you mute your audio. Let's start the program now. Chandrika, have you joined? Chandrika? Chandrika, have you joined? Chandrika?
Hello.
Yes.
Hello. Am I audible, sir?
Yes, okay.
Good
Okay,
morning,
please
one
start
and
now.
all present. Yes, sir.
Wait.
Okay.
Chandrika, I will give you an
Hi.
introduction and welcome. After that, we start profiling.
Okay, sir.
Good morning to all of you. Respected Principal Sir, Vice Principal Sir, and dear faculty members of CSA department and all other department faculty members, dear student participants, I would like to welcome you all in the webinar on Intellectual Property Awareness Program. On the occasion of this webinar, a resource person, Srimati Savari Bhavana Madam, has joined with us for giving awareness program on intellectual property rights. Nowadays, each and every student, even faculties and students, should have a knowledge on intellectual property and its rights. Even third year level, the students have the subject on IPR. We need awareness program on IPR and its related pros and cons. IPR, which is it's like whatever we have visible properties, the IPR, intellectual property, also one of the property who is having the intellectual ideas, design. Sometimes companies have their trademark, trade secrets and patent. All those things are the intellectual properties. So we should have a knowledge on this. When you go for, after your studies, when you go for a startup company, or when you design a new thing, or design a new algorithm, which is very much useful to registration of this IPR and all. So that's why we are arranging such a workshop here. So on the occasion of this webinar, I would like to invite Vice Principal Dr. S. Bhaskaran Garu to address the gathering. Sir, Bhaskar sir. Phone good. Bhaskar sir. Due to network connectivity problem, Vice Principal is not in this meeting. I'd like to invite Chandrika. Please read the profile of the resource person.
Okay, sir. Good morning, one and all present here. It gives me an immense pleasure and gratitude to speak a few words about our guest and resource person of today's event, Mrs. R. Shabari Garu, MTech PhD. She graduated Bachelor's of Engineering in EC from Peria University and also her MTech in Applied Electronics from Dr. MGR University, Chennai in the year 2008 and pursuing her doctorate in Faculty of Electronics and Communication Engineering at Karpagam College Higher Studies, Coimbatore. She is presently working as human scientist and also as Menley advisor. Ma'am has more than 16 years of experience in the field of teaching from various reputed colleges. Among these years, she has also rendered her contribution to Kuppam Engineering College as Associate Professor and Coordinator of Women Empowerment Cell from 2009 to 2017. She has been contributed in various fields of education system in molding lives of students. She has been as an observer, spot evaluator, and external examiner at university level. Ma'am has also served as NBA, NAC, ISO, and IQAC coordinator in various colleges. She has also taken responsibilities as coordinator of Women Empowerment Cell, Cultural Committee, and Graduation Committee. Ma'am has worked on AI-based energy sustainabilities in smart cities and also patent of same will be published shortly. She has also published various papers from different national and international journals titled Innovations in Smart Technology in 2021 and many more. She has also attended more than 40 faculty development programs and workshops. She is also a lifetime member in Indian Society for Technical Education and a certified Menley advisor. We are so honored to have you, ma'am, as the chief guest of today's event. Thank you.
Thank you.
I would like to invite our resource person, Mrs. Sabari Bonu, madam. I hand over the session to Sabari Bonu, madam. Madam, you can share your screen and start the proceedings.
Yes, sir, sure, sir. First of all, I would like to thank management, principal sir, as well as the coordinators who has arranged such a great event in giving the awareness about the intellectual property rights. And this is the program which is conducted by NIPAM, National Intellectual Property Awareness Mission, as a part of the celebrations of Azadi Ka Amrit Mahotsav. Office of the Controller General of Patents, Designs and Trademarks. CGPDTM had launched NIPAM. There's some noise. As a part of the celebrations of Azadi Ka Amrit Mahotsav, Office of the Controller General of Patents, Designs and Trademarks, CGPDTM, had launched this NIPAM on 8th December 2021 with the objective to impart training to 1 million students in intellectual property rights by 15th August 2022. With active participation and cooperation from the educational institutions, this office accomplished the milestone well before the deadline. In this mission, this office trained more than 11,66,924 students and faculties of all the states and union territories of India. In view of the encouraging response of the NIPAM, the office has launched this NIPAM 2.0. It's in collaboration with TIFAC and other IP facilitators. NIPAM 2.0, the next version of the mission, imparts training in IPRs among students at different levels along with the faculties. This mission specially aims to cover all the districts of India. So far, more than 13.5 lakh students and faculties have already been trained in IPR under NIPAM 2.0. So this is the main aim and theme of this National Intellectual Property Awareness Mission through the CGPDTM. Okay, so now thanking all, I'll share my screen and I'll get into the session.
Hello, madam.
Sir, 1 minute, I'm sharing my screen.
Okay.
Okay, so today's session
madam,
is
it's
all
visible.
about yes, sir, yes, sir. Today's session is all about the intellectual property rights, and I myself Sabari Bonu. So till now, the great introduction I have got, and this is the IPR awareness program conducted through the NIPAM, National Intellectual Property Rights Awareness Mission, and almost all the introduction has been over. And as a woman scientist, I have got been trained under the TIFAC. Photo what has been visible there is when I have been there to the field. And apart from this training under the TIFAC, I have got completed the WIPO PCT distance learning course also. WIPO is World Intellectual Property Organization, and the course is Introduction to the Patent Cooperation Treaty and General Course on Intellectual Property. And also I have completed the NPTEL courses like Intellectual Property Rights and Competition Law, Patent Drafting for our beginners, Patent Law for Engineers and Scientists, Patent Search for Engineers and Scientists. Also received my NPTEL Star Award also for all this. And acted as a resource person in mainly intellectual property rights in various reputed institutions. And today agenda, what we are going to see are all the topics based on the projects, why the projects are important to us, how to choose the projects, and intellectual property, what is the meaning and what for we have to get it, the rights about the intellectual property and types of intellectual property, patent search, how we can be able to do, what are the career opportunities present in the field of IPR and current trends. Okay, so all the people in the engineering at the last final year will be concerned about their projects and why the project is more important. So it's more important to complete your project and how you can be able to select the project. What is the importance of doing a project? Okay, so by doing the project, you can be able to score good marks in your engineering career, as well as based on the marks, you can be able to go for higher studies, or else you can be able to get a job. But apart from these things, normal getting the scoring marks and others, why it is more important? See, the projects are not like others, all the other simple projects. How you have to select the project? What is the importance of it? It should be a solution for the problem in existing. Okay, day by day, we'll be going through number of problems, and for that problems, it should be a solution for it. Okay, so depending on that, you have to select. And apart from selecting the project mainly on this, for getting the resume, if at all you are going for applying a job, what you have to do, you have to submit your resume. In that, project will be playing the main role. So thereby the questions will be totally depending on a project work only. And also if at all you are going for higher studies, there will be giving the letter of recommendation from any known faculty or from your institution where you have studied. So it will be helpful there also. Okay, so how you can be able to select the projects? Okay, see the project while you will be selecting, you have to concentrate mainly on three things. One is the project should be novel one, it should be an innovative one, and the third thing, it should be applicable in industry. That is novelty, innovative design, and industrial application. It should be suitable for industrial application. Okay, so if at all you are selecting the project based on these three cadre, you will be able to get good grades in your academics, and also you can be able to go for your higher studies, maybe in India or else in abroad. Okay, apart from this, the third main option existing is nothing but based on your project, you can be your own entrepreneur. You can have your own startup, and you will be able to, you are capable of giving a job to others depending on a project. So what you have to do, you have to select a project which will be suitable for industrial application. So thereby having your own startup, you can be able to manufacture a product and you can be able to sell it. Okay, and the amount what will be getting, you can be able to invest it to the other projects also. Okay, how do you how it is possible to decide your project? So where and all you can be able to get your idea. Okay, so you can be able to go for normal search engines like Google, or else talking with your friends, getting new ideas, or else getting some new advancements from your guides, relatives, and based on your interest mainly. Okay, so where and all you will be able to find out the information about the trends, about the current trends. So Google, by searching in Google, you can be able to get number of ideas, as well as consulting with the friends. Why? Because you'll be doing your project with along with your friends, and also guides, relatives. So day by day, you'll be going through number of problems. The problems will be solved by you by doing the project. And depending on the interest also, it can be solved. Okay. So now, till now, what we have seen is why we have to do the project, what is the importance of selecting the project, and now only we are getting into the intellectual property based on the project. So now shall we learn about the intellectual property? Okay. So like all other existing property, this intellectual property is not the property which belong to all. Okay. So intellect is nothing but the creations in your mind. Okay, so what is the idea you will be getting in your mind? You will be knowing about the left brain operation and right brain operation. Yes, no. So you will be getting creative idea based on your thinking. Okay, so that source of the intellectual property is your brain. It is nothing but creations. Depending on the number of problems, you will be finding a solution. That solution is existing or evolving from your mind only. It is a creation from your mind. So intellect is nothing but the creation of the mind. Intellectual property is a type of intangible property. Why? Because it cannot be intruded by any others. Okay, so it will be the source as well as it will be the property of the person who is having the idea or the creations. So it is a type of intangible property, not like other physical properties. Okay, so this intellectual property will be of inventions, literary, artistic works, symbols, names, paintings, all these things. Okay. So you have got a creation in your mind, and that creation is a property of you. So what you have to do next? You have to get the right of that intellectual property so that you will be excluding others from intruding or interfering into your property, so that others cannot be able to use your property of intellect. Okay. So the inventions, literary or artistic works, symbols, names, paintings, all these can be used only by you and excluding others. So what you have to do, you have to get the rights for that property. So what you have to do, you have to go for registering it, and the rights through the registration from the government will be the intellectual property rights. So the rights granted to the creators of intellectual property by the government is intellectual property rights. Okay, and one more thing what you have to remember is most of the IPRs are territorial in nature. That is territorial in the nature in the sense the place, if at all you are registering your intellectual property IPR in India, only in India you can be able to make use of it. You cannot go and claim in the other countries. So if at all you want to claim in other countries, or else you want to establish your own company in the abroad or else in international countries, what you have to do, you have to go for applying the PCT application. So the PCT application should be submitted to the WIPO, World Intellectual Property Organization, and there also you have to mention to which country you have to enter it. Only to that country it is applicable, and other countries you cannot make use of. So that's the meaning of territorial in nature. So in which country you are registering and you are granting with a patent or else other intellectual property rights, only in that country you can make use of. That is intellectual property, right? And the main source of the intellectual property is your brain, and having the resources and the labor, you can be able to get your final product as a projects. Okay. And who can create the intellectual property? So is there any limitation in creating the intellectual property? No, there is no limitation in creating the intellectual property. Anyone, even a small kid can have his intellectual property. Housewife, maybe illiterate also, educated people, all A to Z from top to bottom, a small kid to educated people with more than 60 years also. People can be able to register and getting their rights. So now coming to the types of intellectual property, the intellectual property will be classified into mainly based on two things. One is industrial application and the other is man, that is the products what will be getting or else outputs what will be getting based on the humans. Okay. So under the industrial property, patents, designs, trademarks, geographical indication will be, and under the copyright, depending on the human outputs. The next type is, next classification is copyright. And under this copyright, it will be subsisting throughout the India in original literary, dramatic, musical, and artistic works, as well as cinematograph, films, and sound recording. So these are the types of intellectual property rights: patents, design, trademark, copyright, geographical indication, semiconductor IC layout design, trade secret, plant variety. Okay. Okay, so now coming with the first main classification of patents. Okay, so the patents. The main classification of intellectual property right is patent. It is a grant by the government, by the sovereign authority or as a state to a person, and it is giving the exclusive right. So what is that exclusive right? It is stopping others from making, using, exercising, vending, and importing it. So if at all you are having your own project, the product is there with you. So what you can do, you can be able to manufacture it, you can use it for your own use, you can excise it, you can vend it, and also you can be able to import it. So all these things can be avoided from others. So why? Because you have got the exclusive right by registering under the government and you have got the rights. It has been granted. So because of that, you will be getting the right of excluding others in interfering with your project or the product. Okay, and it's an invention, but it is for a limited period of time only. So once if you register a patent, you can make use of it only up to 20 years from the date of filing. Okay, and in exchange for disclosing it in a patent specification, such that anyone having average skill in that art can reproduce the invention. So this patent is giving the right to exclude others from using your invention. Okay, so only the owner will be having all the rights to making use. Okay, and the next slide is giving you about the famous inventor and inventions. So in the slide we can be able to see an inventor is the person George Alfred D. Penning. He is a civil engineer of Calcutta, petitioned the government of India for granting of exclusive privileges for his invention. So the invention of him is an efficient Punka pulling machine. Okay, and other inventions also: phonograph, telephone, aeroplane, rabies vaccination, penicillin, and these inventions are from the scientists Thomas Alva Edison, Alexander Graham Bell, Wright brothers, Louis Pasteur, Alexander Fleming, and all. Okay, and you can be able to see some famous Indian inventions: a nano car, a hepatitis vaccine, a Jaipur foot, and this Jaipur foot is made up of affordable prosthetics. Okay, and now can be able to see some of the measures where you can be able to see the one which is giving the solution. Okay, so it is giving the solution for the existing problems. Okay, it's not a big invention with the investment of crores and crores. Only the small inventions has been registered and got the patent rights, and which can be able to manufactured by the inventor, and he can be able to sell his own products, being an entrepreneur or else having a startup. Okay, now coming to the application filing process. Okay, so patent you are having, that is you are having a project which will be of novel, which will be of innovative design, and which will be of an applicable one in the industry. So that application you have to file. So what you have to do, what is the procedure you have to follow for filing your patent application? Okay, so under the Indian Act 1970, you will be having different forms. Okay, so forms, the same form cannot be used for filing all. Different forms has to be used for each and every thing. Okay, so first form 1 is used, for which the form 1 is used is, this form 1 will be consisting of details of the applicant. Okay, so who's the applicant? It may be an inventor or else a assignee. Inventor can be an applicant. And also the inventor can assign, if at all the inventor belongs to the education institution, if he is a student, he can assign the education institute management to be the assignee, so that the education institute management can be the assignee in filing the application. Okay, so he can be the applicant there. If at all inventor is there, means he will if he himself want to file his own application, then what he can do, he himself can file, so thereby he will be the applicant. So the form 1 will be the giving the complete details about the applicant, and for this form no need of paying any fee, directly the form can be submitted. And next, form 2 is available. So this will be consisting of the details of the invention. Okay, so all the details of the invention will be included in this form 2, and that will be giving the technical invention, that is all the technical information will be given, has to be given in this form. Okay, so it will be consisting of title of the project, what do you want to go for patent, a background of the invention. Background of the invention is, it will be just like a survey of the project from the previous. Okay, whether any existing inventions are there, and what you are doing, whether any advancement is there from the previous invention, all these particulars you have to, that will be the background of the invention. And next is particular of the drawings. Next, brief description of the drawing, brief description of the invention. Claims. Claims are nothing but see, for some specification. So what and all you want to get the patent. If at all you are having a ballpoint pen and you have did some modification in writing, instead of making use of a ballpoint, you have made use of some other and manufactured your product as a pen. And what you have to do, already the ballpoint pen, based on the ballpoint writing, they would have got the patent and they are manufacturing. And now you have got a different method for writing. So that method has to be claimed. Okay, so that will come under the claim. Okay, so the claims, abstract drawings, all these can be given detailedly in the form 2. Okay, so for submission of this form 2 also, no need of paying any fee, only up to 30 pages. Okay, so a complete invention details is up to 30 pages, so no need of paying any fee. If at all it extends more than 30 pages, 31 pages there, means each and every page will cost, you have to pay the fee extra more than this. Okay, and next, 10 claims. If at all your project, for that project you are claiming 10 claims are there, so no need of paying a fee for those 10 claims. And apart from these 10 claims, you want to include some more claims also, so number of claims you have to pay this. And next is form 3, and this form 3 will be giving the detail of the foreign filing of similar invention. Okay, so for getting this information about the foreign filing of similar invention, what you have to do, you have to go for patent search. Okay, so already any other patents is available in foreign countries, you have to do, and that details also has to be filed by you. Okay, even though you are submitting your details of foreign filing of similar invention, the controller, they themselves also will be going for patent searching, and they also can be able to find out the information about this. Okay, for submitting this form 3, no need of fees. And form 5, it is a declaration by the inventor, so it will be giving the declaration as to inventorship, and for this also no need of paying any fee. And next is form 18, it's the request for examination. So once you are applying for your patent, you have submitted the application, then and there itself you have to go for submitting a request for examination. So what you have to do, form 1, form 2, form 3, form 5, along with these 4 forms, you have to submit the form 18 along with these 4 forms immediately. Why? Because if at all you have submitted this form 18 along with these 4 forms, then only you will be getting your examination within the short duration. If at all you are not submitting it, then you have to wait for till more extension. When you will be submitting, from that date, they will be taking some 12 or 16 months for getting your request for examination. Okay, and also if at all you have submitted form 1, form 2, form 3, and form 5, you haven't submitted the form 18, but a certain duration is there. So before the duration, you have to submit your form 18. So what will be the duration is, it should be filed within 48 months from the earliest priority date, or else the filing date. If not filed, means the application deemed to be withdrawn. Automatically they will consider it as withdrawn, and automatically your application is going to be rejected. Okay, So immediately you have to submit the form 18 along with your application itself. If not, you haven't submitted the form 18, what you have to do? You have to submit it before 48 months from the earliest priority date. Okay, so fees for e-filing in Indian rupees. Okay, so what you have to do, you have to get into the website, IPO website is there. In that, you can be able to file your own patent. And for this, what are the forms you have to submit? 1, 2, 3, 5, and 18 at first itself. So while submission, you have to pay the fee. So what will be the fee for different forms? So if at all you are a natural person or startup or else a small entity or educational institute, you have to pay 1,600 rupees for form 1. If at all you are not an individual person, startup or small entity or educational institute, you have to pay 8,000 rupees if at all it's a company. And for form 2, no need of paying fee up to 30 pages and up to 10 claims. But if it is exceeding 30 pages and 10 claims, you have to pay the fee. Form 3, form 5, no need of paying any fees. For form 18, it is 4,000 for a natural person or startup or any small entity or educational institute. And other natural, other than natural, that is company, they have to pay 20,000. So if at all you are a natural person, startup, small entity or educational institute, you have to pay 5,600 rupees for a single patent. Other than these people, you have to pay 28,000. Okay. So, and also one more thing is, being a startup, natural person, small entity or educational institute, you are capable of applying a scheme that is Kapila scheme. That is a central government, central funded one. And if at all you are applying and you are going for filing a patent, this 5,600 rupees will be paid by Kapila. That is, it will be funded from the central people. So no need of paying any fee. So 5,600 also is exempted for the people like natural person, startup, small entity or educational institute. So with zero investment, with zero amount, you can be able to apply the patent, apply for the patent. So where you have to file? If at all you want to go for filing it through the patent office, directly you have to submit your hard copy in the appropriate patent office. The main thing what you have to remember is all the filing need not to be done through patent agencies. Okay, so you are not in need of patent agent for filing. Being an inventor, you yourself, being an attorney, you yourself can be able to apply for the patents. Okay, so patent agents are not needed. If at all your work is novel, if at all you are having an innovative idea and innovative output, and if it is applicable in industrial application, and definitely you are having the confidence of getting the patent, you yourself can apply and you can be able to go for it. Okay, and you can be the person who can be able to get it through the controller also after getting the FER, first examination report also. So no need of having a patent agent in between. If at all you are any known person are there, you can, or else you yourself can be able to file it. Okay, and through the online, you have to make use of the e-comprehensive file through portal https://ipindiaonline.gov.in through e-patent filing, and you have to log into it, and then you can get your project to be filed. So after getting into it, this will be the page. What will be getting? So already you have you will be having the login details, the credentials you'll be having. So through which we can log in into that. And expedited examination. Expedited examination is nothing but, see, if at all you are a startup and you are a small entity and the applicant is a female, or else along with the female, number of male applicants are also there means also main applicant is a female means expedited examination is allowed. Okay, and if at all people belongs to the department of the government and other government establishments, and India as a ISA or IPA in PCT, they will be the member in PCT. An agreement between Indian Patent Office and the Foreign Patent Office, all these are existing means expedited examination can be availed. So what is this expedited examination? Expedited examination is nothing but fastening or else speeding up of the process of getting the examination process. Okay, no need of waiting till they will be conducting the examination. So if at all you have filed for this expedited examination, you can be able to fasten the process of getting the examination quickly, earlier. Okay, so if at all you are in a startup, you are having a startup, if at all you belong to a small entity and main applicant is a female, or else apart from this, the other three conditions, you can apply for getting the expedited examination. Okay, next is patent application processing and how the patents are processed. Okay, so you have submitted your patent application. Already I have told you, the getting the patent or else getting the IPR in only in that country only. In other countries, you cannot be able to get the rights, even though other person and they are manufacturing the same product, also go and interfere into them. Why? Because you have to go and apply under the PCT. That is, you have to submit an patent cooperation treaty application under the World Intellectual Property Organization, and there you have to mention in which country you need the rights. Okay, so to that particular country, the rights can be given. Okay, and now coming to the process. Okay, how the process is being carried out. Patent application, it may be PCT, it may be convention or else ordinary application. And after submission of the ordinary application. So this ordinary application, this is mainly for the Indian territory. So you have submitted your application with the provisional specification. And already I have told you in the form where we'll be submitting the details of the technical information. Okay, so there you have to give the complete detail about the technical information, and you are doing the project, but the project has not been completed. Only 2 or 3 application has been over. Till 2 or 3 more applications are there, and I need the patent immediately and with a quick thing. What you have to do, you have to submit the provisional specification at first. Then after completion, at first you have to submit the provisional specification. After the completion of the complete project, complete application, all the application, you can go for submitting the complete specification within 12 months. So first you have to submit the application along with the provisional specification, and from the provisional specification you can take 12 months of time. Okay, so 12 months of time can be taken, and that screen is visible. There is a screen visible. Yes, now it's visible. No? So now the between the provisional specification and complete specification submission, you can take 12 months. Okay, and this time limit is under the section 904. Okay, so all the sections and the rules are given by Indian Patent Act 1970. Okay, and after submission of the complete specification and before the expiry of the 18-month, the Indian Patent Office, this ordinary application is submitted into the Indian Patent Office only. So the Indian Patent Office will publish your work under the section 11A after the expiry of 18 months. So once you have submitted your application but that is the time taken for submission of the provisional specification is with the application itself. And after that, you have to 12 months for submission of a complete specification. And from the time of submission of your application up to the 18 months, they will take the time. And by that time, they will be publishing your work under the section 11A of the expiry of the 18 months. Okay. So now your work has been published by the patent office. And then what they will be doing, they will be going for examination of the application by the examiner of the patents and designs. Okay, and based on your work, they will be going through all the process and procedure will be going through, and then they will be giving the report put up to the controller of patents and designs. And what they will be doing, they will be issuing the first examination report. FER will be given to the applicant. Okay, so after getting the first examination report, the applicant, what he has to do, if at all it is okay, no problem. If at all any mistakes or any rectification has to be did, or else any justification has to be did by the applicant, he has to go in compliance by the applicant within 6 months. So after getting the FER, first examination report, within 6 months of time, or else he can take somewhat plus 3 months also, but he has to submit form 4 for getting the extension of time. So within this 6 plus 3 month of time, he has to go in compliance by the applicant. Okay, so after this, what controllers they will be doing, they will be hearing the compliance by the applicant, and then again the examination of the amendments by examiner of patents and designs will be did, and again the report will be prepared. The report will be put up to the controller of patents and designs, and next issue of the subsequent examination report will be. Okay, so first you'll be getting first examination report, then after the compliance by the applicant, you will be getting the next one, subsequent examination report. Based on this subsequent examination report, you may be granted with your patent, or else you may be getting the rejection by your patent after the hearing and dispose. Okay. Application process going through, and next going through the patent application of PCT and convention. Okay, patent cooperation treaty and convention applications. Okay, so after the submission of the application, here this will be PCT will be taking 31 months from the date of the earliest priority. So this PCT is the application what you are doing, you have submitted already in the domestic countries. Okay, so in India you have submitted already, and you have to go for foreign countries. What you have to do, you are going for submitting a PCT in WIPO, under the WIPO, World Intellectual Property Organization. So here itself it will be taking some time for getting granted. Yes, no. So now you have extended your application and you want to go for the foreign countries, and then from the date of filing here it will be considered. So 31 months from the date of earliest priority, you have submitted your PCT application, and then you will be getting submitting a complete specification. Here in the domestic, you will be having time for provisional and complete specification. Why? Because it is the first application you have submitted in India, and while going for PCT, this patent would have been granted already. So you would have been come out with all your complete output with the complete specification. So you will be submitting your complete specification there, and then immediately after submitting your application and complete with complete specification, immediately your works get published. Okay, as it is already published or not before the 18 months. Okay, so what will be the procedure again? Again, the examination of the application will be going through. First examination report will be given, and next compliance by the applicant will be did, and then SCR, subsequent examination report will be there, and next based on the hearing and disposal, the patent may be granted or rejected. Okay, so it will be the process followed by PCT. And in convention countries, okay, certain countries, which country you want to get, there 12 months from the date of the earliest priority, a complete specification and publication, FER, SCR, grant or rejection. So this is the normal filing procedure of filing a patent. Okay, and what will be the screening things going on inside the patent office? Okay, so we have submitted your application for patents, which is filed by the applicant. And after getting the application in the patent offices, it will be undergoing screening. Okay, screening and classification, under which classification the work goes to. Okay, so the screening and classification of the patent application will be did here. And what they will be doing, they, if at all the work what you have submitted related to atomic energy, if it is related to the atomic energy, it will be sent to the atomic energy department, referred to the atomic energy department. Okay, and if the work is not related to the Atomic Energy Act, under the section 21 of 1. Okay, so under the section 21 of 1, Atomic Energy Act is there. So it is not recognized as the work which comes under this act. So what they will be doing, they will be sending it to the publication process. Publication work of the application will be did, and then allotment of the application to the examination is examiner is did. And based on the classification, first it has been sent to atomic energy, thinking that it may be belonging to the classification of atomic energy. And if at all the invention is relating to the defense, okay, so if it is related to the defense purpose, then it is sent to the DRDO. Okay, so to the defense department they have sent it. And if the work is not related to the defense which will harm the human being or others, so what will be what they will be doing, they will be giving the work for publication. A publication of the application is did to the public, and then after publication it is allotted to the exam. Okay, so this is the screening and classification going on inside the patent office. Okay, and examination. I have told you, while submitting your application itself, you have to file a form for getting your examination. Okay, so what will be the examination and how and all for what this examination is being conducted? Okay, so what are the types of examination available? Okay, so this examination will be a formal examination or a technical examination. It will be a formal, like getting your background details. And if it is of a technical examination, you have to give the complete detail about your project or else the product what you are having. And next, based on the examiner and controller examination, they will be giving you the first examination report. And this will be consisting of gist of objections. If at all any objections is there, the gist will be given and are communicated to the applicant. Okay, examination on reply of applicant. Okay, after getting the first examination report, what the applicant will be doing, he will be going through the gist of objections. What are the objections that there? What he has to do? He has to go for justifying his objections. Okay, so if it is not related or else if it is good, he has to go for justification and he has to give a reply. Okay, and after submitting the reply of yours, reply of the applicant, the examiners, what they will be doing, they will be checking your reply, re-examining it, remove the objections. If already they have given the objections, means that the objections will be removed which met the requirement. Okay, communicate the pending objection to the applicant, and the next procedure will be carried out. And next thing to this, after the FER, examination on reply to the of the applicant, and next is hearing. Okay, so in the hearing, what the people will be doing, they will be having a technical discussion on the pending objection. So what are the points they have objected? The discussion will be going on the technical matter between the applicant and the hearing officers. Okay, it may be a controllers or examiners. Okay, so between these two people, the hearing will be going on, and after this, they will be giving the patent. They'll be granting you the patent, or else still more the objections are existing, and it's not worth of giving the patent granted. What they will be doing, they will be going for refusal of the patent. Okay, so it's a decision to grant or refuse the patent based on pending objections and submissions of the applicant. So this is the examination process or procedure carried out in the Indian Patent Office. Okay, so the technical examination, what they'll be doing, reading, understanding the invention in relation with the drawing, search for the related earlier publication on worldwide database, that is patent search. This is nothing but the patent search. I'll tell you how we have to go for patent search and which websites or databases we can make use of the patent search. Check for the novelty, inventive step with respect to the citations. Okay, preparing the detailed examination report. Apart from your patent search, the examination people, the examiners they themselves will allot the people for going through all these process, then only they will be giving the report. Okay, prepare the detailed examination report based on all. And you have to know the basic timelines. Okay, so what are the timelines available for submission of your application? Okay, already I have told you, if at all your output is with certain 2 or 3 applications, till 2 or 3 more applications are there pending, what you have to do first, you can submit the provisional specification along with your application. Okay, then after the completion of the complete specification, you can submit the complete specification, that is complete project has been completed, then you can go for complete specification. But what will be the duration between provisional and complete specification? It will be of 12 months only. You should not extend more than 12 months. Okay, so only within the 12 months you have to complete the remaining application. If it is extending till more, you cannot go for extension. Okay, so it seems to be that you have withdrawn your application. A request for examination. So from the date of filing your application, before 48 months, you have to go for submitting your request for examination. Next is replying to the FER, first examination report. So with duration, you have to reply. You have to reply within 6 months of the duration. And form 3, you have to submit within 6 months. Form 5, within a month, you have to submit the form 5. Withdrawal of the application. If at all you are not satisfied with your outputs, you have submitted your provisional specification, and while getting for submission of the complete specification, you haven't got your outputs. Final output is not there. Till more applications are there pending. You are not satisfied with your work. What you can do? You can withdraw your application. So within with duration from the date of filing your application, within the 15 months, you have to withdraw your application. Okay. Next, hearing submission. For submission of hearing, you have to submit within 15 days. Pre-grant opposition. That is, grant. If suppose you have found some patents are going to be granted, and the work is related to you, that work has been done by you, and also you have got your rights. It's been granted already. So what you have to do before getting the other people going to be getting the patent granted, you have to submit your opposition. That is pre-grant opposition. Okay. So before the grant of the patent, you have to go for filing your application for opposition. Okay. And next is post-grant opposition. Already some people, they have got their grant for their patent, and it's known to you later. Okay. So, but what you have to do? You have to go for filing an opposition. So you have to file a post-grant opposition, but it should be within 1 year of that grant. If at all it has been extended for more than 1 year, you cannot go for opposition. Okay. Okay, so this is the all about the patents and the filing process of the patent. And next, coming to the next types of the intellectual property rights, it's nothing but copyright. Okay, so other classification of the intellectual property, it is copyright. And for which work? Already you know patents, it's based on the products. Okay, project what you are doing, and the product what you have did, you will be getting your patent right. And the other classifications are also there. That is a copyright for which work you have to get your copyright. Okay, so it may be literary, dramatic, musical, or artistic work. It may be for anonymous and pseudonymous works. It may be works of public undertakings and government works. It may be works of the international organization, a sound recording, or a cinematograph films. So all these comes under the copyrights. Okay, and if it is a literary work, okay, so author of the book, he has authored some books, and it has been published, and he has got the copyright also for that. So how long it can be used? Till the lifetime of the author plus 60 years. That is, after the lifetime of the author, it has been assigned before death itself. He has assigned the work to some others, assignees or existing. So up to the lifetime of the author can make use. After his death also, up to 60 years, the copyright can be used. Okay. And next, for anonymous, pseudonymous, as well as all the other sound recording, cinematograph, all these works, up to 60 years, it can be used. Copyright, it will be for 60 years. Under the copyright literary work, lifetime of the author plus 60 years. So music as well as all these works that comes under the copyright, and they will be getting the copyrights under the Copyright Act. So as the next type of the intellectual property, it's a trademark. By seeing the images, you can be able to tell. By seeing a tick mark, directly you can be able to tell it's a Nike company. Yes. So next is Adidas, McDonald's, Blue Dot, Indian Post, FedEx, all this. By seeing the images itself, by seeing the mark, it can be able to tell to which company it belongs to. It's a sign capable of distinguishing the goods or services of one enterprise. Okay, so only to that enterprise or that company, they are the manufacturer of these products. Okay, so you can be able to tell why, because they have got the rights of their trademarks. And one more thing, what you have to remember is, you would have seen TM and R being circled. Okay, so what will be the difference between these two, TM and R? R is nothing but they have registered for a trademark and they have got the rights also. Okay, TM is they have registered, but the process is going on. They haven't got the final grant. Okay, so it is TM. They would have been mentioned TM or top to top right corner, it would have been mentioned. If it is R circled, means they have got the right, it has been granted already by the government. Okay, so how and all the trademarks will be? It may be a brand name. Okay, by seeing the brand name, you can tell it belongs to which company. It may be a tagline or slogans, like Life's Good, LG, Life's Good. KFC, it's finger licking good. And McDonald's, it will be I'm loving it. Likewise, it may be a tagline or some slogans. Okay, and sound marks also. Sound mark like a lion roaring. Okay, so it belongs to Britannia company. And logo, it may be a combination of colors also. See, like here, you can be able to see orange. Okay, even this color also can be, has been trademarked. It may be a name, it may be a logo type, it may be a symbol, it may be a slogan or a color. Okay, so all these comes under the trademark only. And next comes the next type. It's nothing but a design based on the design of the products. Okay, so it may be based on the design of the bottle or else any machines, machinery works. Even the lines. See here, you can be able to see the lines. It may be downwards, upwards, or else a straight line, depending on the design, how they have designed it. They can be able to get their right for designs also. Okay, see in the first, you can be able to see number of design for water bottles, all these shapes. Okay, so all these designs, it may be for ornamental or aesthetic aspects of on an article. The features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether it may be in a two-dimensional one or three-dimensional or in both the forms. Okay, so by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, even if it is separate or else combined things are also present, means also you can be able to get, which is in the finished article appealed to and or judged solely by the eye. Okay, so you can be able to get by the design. And next comes the semiconductor integrated circuits design, layout design. See what is semiconductor integrated circuit. Being a CSE people, all will be knowing what is semiconductor integrated circuit. It is nothing but a product. Okay, so that design will be consisting of number of transistors or else other circuitry element which is designed to perform an electronic circuit function. And what will be the layout design? Layout of transistors and other circuitry elements, including lead wires connected in a semiconductor integrated circuit. It will be the layout design. Okay, so now you will be knowing what is a semiconductor integrated circuit layout design. Okay, what you have to do, you have got your specific design. Layout design is present with you, and that design should not be used by others. So what you have to do, you have to go for registering it, like how you will be going for registering the patent. You have to register this also. So under
madam,
which act you can design, you can register this is, it will be the Design Act, Semiconductor Integrated Circuit Layout Design Act, SICLDA 2000.
madam, your
Okay.
screen is not visible.
Screen not visible, sir.
Screen visible. Ah,
It's visible on this. Clear, sir? Okay, so under this SICLDA 2000, it is visible, no, sir?
yes, ma'am.
Yes, okay. Okay. So 2000, it will be dealing
Okay,
with the
ma'am.
layout design used in the semiconductor integrated circuit, and it's a form of an intellectual property. Okay. And what this act will be giving you? This act will be providing you the protection for a period of 10 years. Okay, even for trademark, copyright, as well as for semiconductor integrated circuit layout design, it will be given the 10-year of applicable. That is, you can be able to make use of it up to 10 years. And if at all you want to extend the duration, means you can go for renewal process. Okay, so you can be able to go on renewal after 10 years. And next, what will be the criteria for registration? You are having a semiconductor integrated circuit layout design, it's your own design, and based on what factors you can register. Okay, what are the criteria being followed for registering it? It should be a original work. It should not be a copied one or existing one. It should be distinctive. Okay, it should be distinctive one from others, and it should be capable of distinguishing from any other layout design. It should not have been commercially exploited anywhere in India or in a convention country. In any other country, it should not be used. Okay, next comes the geographical indication, GI. So by seeing the images itself, you can be able to tell what it is. Yes, no. So the product which is available in that particular area, geographical area, can be registered under the geographical indication. Okay, so all the remaining intellectual properties can be registered by an individual person, but the geographical indication cannot be registered by an individual person. It has to be accompanied by a company or else the government. It may be state government, collector, or someone has to accompany him for registering the geographical indication. So an individual cannot be able to go for registering the geographical indication. Okay, so what is the geographical indication? It is an indication that identifies a product that have a specific geographical origin. So from that area only you can be able to get that product. From no other places you can be able to get. And also it will be possessing the qualities or a reputation that are due to that origin. Okay. So like Darjeeling tea, Makrana marble, Ratlami save, Kanchipuram silk, Madurai Malli, Wayanad rice, Nilgiri tea, all these are the origin from the particular geographical area. So that comes under the geographical indication. And next comes the next type, it's a plant variety. Okay. Apart from the geographical indication, the type, variety of the plant can also be registered under the intellectual property rights. Okay. So this act will be aiming to establish an effective system for the protection of plant varieties. Okay. So if at all you are having a new hybrid variety of any type of plant which is yielding more, you can go for registering that plant variety and you can be able to get the right. Okay. And it is giving the right of the breeders and to encourage the development of new varieties of plants. Okay. And based on which criteria this plant variety can be given, it is the plant variety should be novel, distinct, uniform, and stable to be registered. Okay. An example of this is Lay's chips. Okay. The people of Lay's chips, they are having their own hybrid of potato, which is used by only by them, and others cannot. Other farmers cannot make use of. Next comes the trade secret. Trademark will be the slogan, design, or not the design, slogan, or any sign. And trade secret will be, if at all you are having any cooking recipe, what are the ingredients you have made use in it, and the process or making method will not be used by others. For example, you can take the Coca-Cola. The formula used for making the Coca-Cola can be used only by those people. And next is Big Mac special sauce, which is prepared by those people only. And KFC chicken recipe, WD-40 formula, all this. they have registered under the trade secret, and that secret cannot be revealed or else it cannot be used by others also. Okay, and it is a confidential business information which provides an enterprise a competitive edge. Okay, it will be considered as a trade secret. It will be giving you the manufacturing or industrial secret and also the commercial secret also. And these trade secret can be included the R&D information, software algorithm, invention, design, formulas, financial records, ingredients, list of customers, devices, methods, consumer profiles, and advertising strategies or policies of a company. Okay, so all these comes under the trade secret. If at all you're having a thing which you can manufacture or else you can be able to prepare only by you can register it under the trade secret. So for the patent, you have seen number of things already. We have gone through this patent process and the application filing procedure. All this we have seen. Okay, so now coming to the summary of all the patents. Okay, so types of intellectual property, it will be patent, design, trademark, copyright, geographical indication, semiconductor, layout design. And so what is based on which type of work has been given in the middle column. And what you have to remember mainly is what will be the duration of all the intellectual properties after getting granted. Okay, so for patents, you can have only up to 20 years. More than 20 years, you cannot go for making use of it. And even no renewal of your patent is also available, but for some certain criteria. Okay. And for design, first they will be giving you 10 years. And once you go for renewal after the 10 years, for 5 more years, it can be given. And for trademarks, it is indefinite. First, they will be giving for 10 years, and then you can go for renewal of the thing for every 10 years. And next for copyrights, if it is a book, you can have it for a lifetime plus 6 years, and other works for 60 years. For geographical indication, even this also can get 10 years, and after the 10 years, you can go for a renewal process. Every 10 years, you have to go and renew. For the layout design also 10 years. This is just 10 years, not more than 10 years. Even patent also 20 years, not more than 20 years. Okay, so patents will be granted for inventions, that is a project or products, and it will be for one patent. If at all you are having one invention, and that can be filed, and after filing you will be getting one patent. One invention, one patent. A patent is valid for 20 years, starting from the date of filing. Okay, so when you have filed your patent application, from the date it will be considered, and this term 20 years cannot be extended. So what is patentability? Okay, already I have told you, you have to find out whether your work is already existing or not. Okay, so you have to go for finding whether your project is patentable or not. Okay, so what you have to do, you have to go and check whether your project is a globally new idea or not, whether either it may be a process or else it may be a product, or else the research work which is published within 12 months. Okay, whether the research work is published already means it cannot be patented. Okay, you cannot publish the work already in any source. Okay, it should not be published already. Why? Because it will be known publicly already. The publication can be did only by the patent offices after the submission of your application. It should not be published. Okay, and you have to check whether any technical advancement in the product or process is there already, and the thing is related to the industrial application, whether it is having the commercial value or not. All this you have to check before going and filing your application. You have to check whether it is patentable or not. Your product or project is patentable or not, whether it is patentability or not. Okay, so invention means a new product or a process which involves the inventive step capable of industrial application. So you have to remember the three main things. One is novel, another is innovative design, another is industrial application while submission of your application. And this will be the form 2 where which will be making use for submission of your technical background. This form is given under the Indian Patent Act 1970, under the section 39 of 1970 and the patent rules 2003. Okay, so this same application, the same form 2 can be used for giving the provisional specification as well as for the complete specification. Okay, so this will be consisting of all the background details, technical information. Some examples of already existing patents. It is WO201104444642. It is the patent number. Okay, already granted patent, and this patent has been granted for the system for indicating movement of an article from one position or orientation to another position or orientation. Orientation is nothing but movement. Okay, so what will be? So for which it would have got this patent granted? It's nothing but in the cricket ground, they have got the patent granted for finding out whether the stumps has its movement, orientation has taken place there or not. Okay, so this two pieces has got their patent, glowing the LEDs. And next example, US 8695457B. Okay, so this is a patent number, granted patent by the US. First two letters will be giving you the country, which country it belongs to. It's nothing but a pop-top can opener, design of all the lids. Okay. So by seeing this Coca-Cola lid, you can have the idea what these are. So this is the patent granted for pop-top can opener. And one more patent, US 525545-2A. This patent has been granted for method and means for creating anti-gravity illusion. It's a shoe which has got a patent for getting the anti-gravity illusion, and the works carried out inside it. And one more thing, manufactured Indian one, Band-Aid. Okay, so what the person of manufacturer of the Band-Aid did, he took two of the company's earlier product. Okay, already in the same company they have manufactured adhesive tape and gauze. Okay, both he has took and combined it into making a single one, that is Band-Aid. The final product what he has got is Band-Aid. It keeps the adhesive from sticking. He covered it with the crinoline fabric. So this is the final product of the Band-Aid. And some simple inventions to solve the routine problems. So already I have told you how to select the project based on the simple normal existing problems. You have to find the solution. Okay, so it need not to invest crores together for getting a new project. Some simple investing rupees also you can be able to get. Leveling up of the land with simple procedure he has followed, and this zip with a stopper and thread, inserting a thread into needle, this simple invention. So there are more than 200 patents on safety pins and paper clips. A pizza cutter along with the base. Okay, so that after cutting, piece can be taken easily, more easily. And next, spreading the butter on a bread without sticking it on the hands, and seeing the shape of the watermelon, you can be able to understand easily. Eating of the watermelon in a round shape is more difficult, so this will be helpful. And chairs different with the different applications. Why is IP important to us? Intellectual property, in what form it is important to us? So if at all you are in need of getting the intellectual property rights, what you'll be doing, you will be going for getting new and exciting inventions. You will be thinking for getting the new idea. And based on that, you can be able to be an entrepreneur, or else you can be placed somewhere in companies, topmost companies, so that you can be able to get a job for you as well as for your family. And it will be giving you the stronger economy. It helps you find your favorite products. And also for the authors, textbook, some books they have authored means they will be rewarded for their work. Helps the household items to be useful and look good. Okay, so patentability you have seen, and patent search, how we can be able to go for patent search. Okay, so now you have a project, you went for patentability, whether your project work is applicable for applying for a patent or not, you have to see. So what you have to do, you have to go for patent search, whether the idea is available already or not, whether the product has been patented or not. You have to check it. Where you can check, you have to go for patent search in the databases. Some free databases are available, like our normal Google search engine. Google patent search is also available. So in that you can go for searching the patents. So what you have to make use, you have to make use of the keyword, main keyword. If at all your project is depending on the IoT, you have to type IoT in the search column, and then you can be able to get number of patents which is related to the IoT. Okay. So like you have to make use of the keywords. And in advanced patent search, what you can do, if at all you want to know whether the project is being patented already for back 20 years. Okay, so before 20 years it has been granted means also it's not a problem. Why? Because every patented items can be used only up to 20 years. They can extend till more also, but patent validity will not be available after 20 years. Only after 20 years it is available. So after 20 years, anyone can make use of it. It is public. Okay. So you want to go for finding out whether within these 20 years, last 20 years, the idea of yours has been patented or not. In that advanced patent search, you can give the duration, today date, and 20 years back the date, so that you can be able to get the output. Next, patent search India. In the Indian Patent Office website, ipindia.nic.in, you can be able to search number of patents available. eSpaceNet, it is European database. And Patent Scope, it is World Intellectual Property Organization database. The Lens, LifeCast, all these comes under the free databases. You can make it use freely. And next, paid database also there. And these paid databases will be used by law firms, LLPs, and companies. Softwares, MNCs also make use of it for finding out whether the product what they are having is being patented or not. So these people, they will be making use of the paid databases like Questel Orbit, Total Patent, LexisNexis, MicroPatent. Okay. So what will be the difference between the free database and paid database? See, in this free database, what you will be doing, you will be giving certain keywords, and based on that, you will be getting. So here in this paid database, giving a certain single keyword itself, complete detail about all the patents. You can be able to get the details completely. Okay, so no need of going for searching again and again. It will be giving the complete database. It will be reducing the usage. That is, time can be consumed. It will be reducing the time of search. But here you have to invest more time. Why? Because it's free database. So you have made use of a domain. Here IoT has been used, and the keyword is typed there in the search column, and after typing it, you have got the output like some certain patents already which has been published. Okay, so in lakhs, the outputs they have got 2 of lakhs, that is the displaying things have got like. And trends in nowadays existing today, trends in technology are AI animation, 5G networks, virtual environments. Some top new inventions in 2020s. It will be of humanoid robot Ameca, color changing cars, freestyle, Moveno ring, Target Cypress, Hero backpack, Encode Plus Smart Wi-Fi deadbolt, Samsung Echo remote, robotic cat. All these are the 2020s new inventions. And the frontier technologies accepted by WIPO people are Internet of Things, digital technologies, blockchain, metaverse, artificial intelligence, big data, and cloud computing. All these has been identified as the frontier technology. And also physical technologies such as autonomous driving, 3D printing, and hardware innovations. And also in the field of biotechnology, biological technologies such as genetic engineering, human augmentation, and the brain computer interface. Okay, so all these and other top new technology trends are also. And some more new inventions, finger resistant bands, wearable immersive virtual reality Parkinson's disease patients, and pain relief physiotherapy equipment. Day by day, the inventions are going on. Okay, and now you can be able to
10,000 ఇస్తే కరెక్ట్ గా సరిపోతుంది నాకు పాస్ ఎగ్జామ్ ఫీజు కాలేజ్ ఫీజు
Students, mute your audio.
and you can be able to see a page which is the Google patents. So you have opened a Google patent search, and in that assignee has been given a keyword Google LLC. Okay, so based on the depending on the industry is Google LLC, and the priority you have given the date, first date of January 2022. Okay, so date of priority it has been given, and the company it's of Google LLC. So based on the industry it has been searched, and the number of outputs you have got, and more relevant you can search and you can get. And next is depending on the domain. Okay, so cloud domain has been used here, and depending on this domain you will be getting the outputs. These are the keywords what will be making use for searching. And output what we have got is will be a page like this. If at all you want to download, you can go for download PDF. It's a patented one, patent out. Okay, so already they have got the patent for the work displaying content items based on device status, and the patent number is US 202202100002A1. Okay, so first two letters will be giving the United States told, and here down you can see the inventor Wu Jin Chung, current assignee is Google LLC, and it has submitted its worldwide applications under WIPO. PCT applications has been supplied as well as conventions also. And next priority date, application filed date, publication date, and what is the status, whether it is granted or not. Status, it would have been granted. Okay, and all these things, and the left you can get the details about the patent also, abstract images, all you can get all the complete details about all the patents already been granted all over, not only in India. Okay, so you have made use of Indian Patent Office website ibindia.nic.in, and in that you can be able to download your patent document, whatever you are in need you can be able to download. All this comes under the patent search. Okay, so these are the benefits. You can be able to find out whether the work is related to the previous existing patents or not, whether you can go for applying for patent or not. All these things can be done by yourself, and after coming to a conclusion you can go for registration. Okay, so what are the benefits you'll be getting based on the patent search? You can be able to know the new inventions in the current technology, and whether it is applicable in both industries as well as institute, as well as it's whether it is a new product, and if it is having any limitation to it, and technology trends, all these. Okay, so it will be helping you in your innovative research. Okay, in implementation, description, and components, and it will be giving you the better information also. Okay, and it will be including the patents in your literature review. You have to give the literature review also while submitting your background information in the application. Okay, and it will be improving, and if at all any existing you can go for improvement, modification can be did earlier before submission also, that also can be did. Okay, and some points what you have to remember will be first protect then publish. Okay, if at all the work has been published already, you cannot go for filing your patent. First protection is needed, so you have to file for patent or else other things, other intellectual properties, and then you have then the publication can be did automatically. Okay, and rights are territorially in nature. It will be, it can be used in territorial. It is having its boundary limitation. Okay, it is limited to boundary of the country or the authority. And for all this, registration is required. In which country you want to do, you have to go for registration. Registration is done by the sovereign authority, that is Government of India. You have to go and submit your application. Registration can be did by means of Government of India. Indian Patent Office people can be able to do all this. Rights for limited period of time. For a patent, it is 20 years. And for geographical indication, you can be able to get it for 10 years. Renewal, it is of indefinite. And for copyright, it can be 60 years. If it is the textbook or author of the book can be able to get till the lifetime of the author plus 60 years. And remaining all the works, it will be for 10 years plus renewal. The semiconductor IC layout design, it's for 10 years only. Patent and semiconductor layout design, it will be only 10 years. It cannot be extended. No automatic relief can be given. Why? Because you have got your patent project patented, but even then you have found out someone making use of the same idea and same product. What you have to do? You have to go for filing an infringement suit against them. Okay. Renewal fees has to be paid for some IPRs. And one more thing, what you have to remember is signature of patent agent is not compulsory. Okay, why? Because applicant, he himself can be the owner, he himself can be able to submit the application, and he can face the authorities in hearing also. And what are the career opportunities available in this? The government side, you can be an examiner of patents and designs, examiner of trademark and geographical indication, examiner of copyrights, and others. Apart from these jobs, you can be a patent agent, trademark agent. But for being a patent agent, trademark agent, you have to clear an exam conducted by the Indian Patent Office. Yearly once the exams are being conducted, and you can be a junior research fellow or senior research fellow in patent facilitation centers. Patent litigation and other opportunities in the private sectors are also available. Even in the software companies, MNC companies, even in others, IP firms, law firms, LLPs are available, where also you can be able to get the jobs. Okay, already I have mentioned a Kapila scheme is available. This Kapila is nothing but Kalam program for IP literacy and awareness. Okay. So if at all you are applying for this Kapila scheme and you want to apply your project for getting patent, 5,600 rupees can be funded. Funding assistance can be did. So you can be able to get up to 5,600 Indian rupees per application for patent filing. So for a startup, for individual applicant, for educational institute, no need of spending even a single rupee for filing a patent, for getting the patent. And IPR awareness programs can be conducted, IPR courses you can do, and thereby the economy by the patents can be. Okay, so that's about the intellectual property, intellectual property and intellectual property rights. And if at all you have till more doubts or else you need still more information, you can contact me, and the link what has been sent, you can register so that you can get your certificates. Sir?
Yes, madam.
Sir, I think it's completed. Remaining filing procedures for others also available, but it will take more time. So I have completed up to this.
Yes.
Patent is most useful for all the people. So I have done with this.
Okay.
Okay.
Sir, Nyanamud sir.
Sir. Hello.
Yes, we can.
Sir.
Madam, do you
Sir,
have
here goes.
any feedback form?
No feedback form, just the registration form.
Okay. We have a feedback form that we will share.
Okay, sir.
Okay. Sir,
Sir,
Nyanamud sir.
can you take a snap of all the people? I need the photos to send.
Okay, madam.
So shall I start, sir?
Yes, sir.
On behalf of all students and staff, I'm glad to express my vote of thanks. My special thanks to our chief guest, Mrs. R. Sabri Banu Garu, for accepting our invitations, for being here with us today, and given wonderful sessions to us about IPR. And I thank the management and our HOD of CS Department, Dr. Lokeshwar, and other faculty members for conducting this special event. And thank you one and all.
Okay. Sir, over.
Sir, please
Madam.
give feedback link, sir.
Okay, I will share the feedback. Madam Sabri Banu ma'am, thank you very much, which is very much useful for us and for our students also. And I would like to thank even the officials from the Department of Promotion, Industry and Internal Trade, Ministry of Commerce, Government of India, and the team of NIPAM, National IP Awareness Mission. Especially thank you very much for our resource person Sabri Banu madam also. So I will share the feedback. Students, you can fill the feedback and then you can leave from the session. I will share the feedback in YouTube and also in the Zoom. Feedback link shared in the Zoom. And also now feedback will be, link will be shared in the YouTube channel. YouTube photo.
Okay, I'm leaving the.
Feedback link shared in YouTube and the Zoom meeting. So you can fill the feedback and you can leave from the meeting. Madam, thank you very much, madam.
Thank you, sir. Thank you so much.
Maximum third unit, complete patent unit. We have a record as if record we can.
Oh, it's in live also now, sir. Yes, we can see you. Sir, live off.